All right, a very good afternoon, wherever you're joining us from. It's a rainy afternoon where I am in Arusha, Tanzania. It's raining cats and dogs, but nonetheless, the room is warm and the environment is getting heated up for a very wonderful discussion this afternoon. And yeah, as you're settling in, please. Feel right at home. You're welcome for this wonderful session. Please tell a friend to tell a friend that our session is on right about now. We're streaming it live both on YouTube and on our Zoom platform. And as we begin our session this afternoon, we'd like to begin with a simple thought. Many of us, lawyers of course, spend years mastering the law, statutes, precedent, procedure, advocacy. But the lawyers who truly build enduring careers understand something even more powerful, and that is how clients think. Because clients today are not asking, do you know the law? They are asking, do you understand my business? Do you understand my risks, my pressures, my priorities? And increasingly, the answers to those questions are being shaped inside organizations by in-house counsel and general counsel who sit at the center of strategy, governance, and decision making. And that's why, friends, this webinar this afternoon is of paramount importance. Our webinar, Inside the Client Mind, what in-house and general counsel are watching and why it matters for your career, gives us this very rare opportunity to hear directly from those who sit at the other side of the table and decide which lawyers become trusted advisors and which remain just another name on a brief. And guiding us through this important conversation is someone who understands both worlds. Our moderator, Mr. Kambaha O'Brien Karogo, is the head legal and company secretary at Guarantee Trust Bank Uganda Limited, having successfully transitioned from a very and private practice arena to leading an in-house legal department. Brian brings a unique dual perspective on how legal services are delivered, evaluated, and trusted. Now, with over a decade of advising corporations and financial institutions across the region, Brian brings exactly the insight needed to help us unpack why clients truly value lawyers who have a certain understanding in today's legal market space. Ladies and gentlemen, it is now my great honor and pleasure to invite our dear moderator, Mr. Brian Karogo Kambaho, to take on this session. Brian, I'll hand it over to you. Friends, if you have any questions at the back of your mind, please feel free to post them in the Q&A segment and yeah, enjoy the conversation. Brian, over to you.
Thank you, Gabriel, and thank you, East Africa. Thank you to the organizers for inviting me and my panelists for accepting to join me in the conversation. I am live in Kampala, and I would like to know from the various attendees where they are. So please, in the chat room, could you just tell us where you are logging in from, such that we can have a feel of where across East Africa our listeners, our viewers, whoever is attending is logging in from. Good afternoon once again. And yes, I have a very esteemed panel. But before then, please keep the messaging coming in. I see we have people from Rwanda, from Kenya. I would like to see some people from Tanzania, some of our own Ugandans. Please keep the answers coming in, and I'll be asking Gabriel to point me to the chat room whenever there are any questions. So a very warm welcome once again in today's webinar hosted by the East African Law Society. The theme has been mentioned to you, and the interesting realities is legal practice is indeed on both sides, in-house and external. Now with me, I have two distinguished panelists, and I'll start with Ahenda Anjichi. Ahenda Njichi is an in-house counsel with over 12 years of experience across financial services sector in East Africa. She currently serves as the principal legal counsel regulatory affairs at the Kenya Commercial Bank, where she leads the bank's regulatory engagement. In this role, she spearheads the development of KCB's organizational approach to regulatory engagement, advocating for responsible policy outcomes that align with business goals. She has previously held senior leadership positions at Loop, DFS, NCB, A Group's fintech arm. She worked with Jumia Pay and Tala, where she secured key financial service licenses, built regional legal and compliance frameworks, and led structural engagement with regulators within Kenya and the region. With expertise in compliance by design product development, she brings both a strong policy foundation and practical insight into navigating regulatory complexity. She's passionate about shaping policy frameworks that enable responsible innovation, strengthened institutional resilience, and support sustainable growth across Africa's digital finance. So please welcome with me Ahenda Anjichi, and I believe you'll tell us if you want us to call you Ahenda or Anjichi, and I hope I'm pronouncing Anjichi rightly.
Yes, Brian, thank you. Ahenda is just fine. Pleasure to meet everyone, and looking forward to this panel discussion.
Fantastic. Next on the panel is a friend that I know closely, Andrew Mauso. Andrew heads the legal credit unit at Stanbic Bank Uganda, which is a leading financial institution within Uganda. Previously, he worked with Sebalulu, their advocate. So he also comes on board with a dual experience, both from external counsel and internal counsel. At the bank, he's currently spearheading a big team and doing a turnaround within the banking space. This morning, he was instrumental in sharing tips to do with alternative dispute resolution with judges and the Chief Justice of Uganda and the Minister and many other stakeholders. So I know Andrew is keen on sharing his lessons both to young lawyers, fellow experts in the room, and Andrew, it's a pleasure to have you here.
No, thank you for the kind words, Brian. The pleasure is indeed mine. I'm excited to, have a conversation with our colleagues across the region. Happy to have them here and happy to be here. Thank you.
Awesome. So I'll go straight in, and yes, back to our chat room. I see we have people from Kampala, Mbara, Uganda, Kenya, Ruth Rotich, Lucas from Tanzania, Nakuru, Kenya. Thank you, members, and we hope that you enjoy the ride. So one of the most interesting realities of legal practice is that many lawyers indeed spend a lot of time perfecting legal knowledge, yet relatively little time understanding how clients actually think, how decisions are made within organizations, and what ultimately drives trust in professional relationships. Now, today's session, we seek to bridge that gap by bringing advocates a rare opportunity to hear directly from those that are in-house, including myself as the head legal and company secretary of a financial institution in Uganda. And we regularly engage external counsel in the course of our work, and we hope to explore what keeps us as in-house counsel awake at night. What distinguishes lawyers who become trusted advisors from those who remain simply transactional? And most importantly, how is the legal landscape evolving in this increasingly complex and fast-moving businesses like the tech world and the former Jumia Pay, where Ahenda previously worked? So we hope that ultimately, when we close this conversation, we have left you, our fellow advocates all across East Africa, with practical insights on how to build a stronger client relationship, but most importantly, how to position yourselves for long-term professional relevance. So to begin the conversation, I would like to start with a question that often surprises many lawyers when they hear the answer from the client side. So for today, dear lawyers on the other side, I have the actual client in the room and I get to ask them, today I'll be wearing the hat of the external lawyer, even if I am also an in-house lawyer. And maybe once in a while I keep changing hats. I wish I had come with actual physical hats and put on this one and put on another one. So I'll ask to the both of my panelists to kick that us off. What is the biggest misconception that external lawyers tend to have about how in-house legal teams operate? And I'll go with you, Ahenda first, and then Andrew will come in. What's the biggest misconception about what external counsel think of in-house role?
All right. Thank you, Brian, to start us off. I think I'm the first one to have the privilege of being on the hot seat. So I think when it comes to external counsel and our engagements with them, I think the first, well, I wouldn't call it a misconception, but I think the first thought is usually that in-house counsel, our role is just basically to be gatekeepers of the law and to defend the law. But I think our role goes deeper than just understanding what can be risky. I think what the external counsel need to explore further in their briefs and as they support us as in-house counsel is that not only are we the risk we are not only the risk champions when it comes to, navigating regulatory framework and understanding how the business plays into that. But I think what is really important for external counsel to also appreciate is that we are also the solution givers. So in as much as we are expected to point out what may be risky, what the actual regulatory framework expects of the business from a compliance perspective, I think more than that, we are called to be in-house business partners for the business, and we're required not only to just highlight what the risks may be from a practical commercial perspective, but also to come up with creative solutions for the business, because at the end of the day, as in-house counsel, we are expected to be strategic growth enablers for the businesses that we work in. So I think that will be my first comment to kick us off.
Awesome. Thank you, Ahenda. Andrew, tell us, what are your perceived misconceptions, or when you crossed over? Actually, I should maybe make it more direct. When you crossed over from the law to now come into in-house, did you realize that it was a misconception? Everything you knew was a lie?
Absolutely, Brian. And when you asked that question, I got excited because I think for me, and like you, crossing over from law firm practice into in-house role, the misconception that stood out for me, and which I had, and of course which I have since disabused myself of, was that in-house counsel are there to just shuffle paper about, just push paper, pick documents, pick briefs about disputes, or pick briefs about legal problems, and then shuffle them over to external counsel. That in fact there is no engagement with the legal issues. There's no engagement with the issues that are really bothering the business, or that are a problem to the business. But of course, I have since learned and realized that in-house counsel do much more than that. If I can use an analogy, I would look at them as the first line of defense, and they deal with the issues in real time. If as to use the analogy of a fire, if a house was on fire, in-house counsel are the guys within the house who come with the buckets of water to try and put out the fire. And when they feel overwhelmed, and they will always be overwhelmed by the fire, then they will call on the external counsel. So these are two sets of professionals doing the same thing, but at a different vantage point, right? In-house lawyers are in the fire, dealing with it as it happens, and occasionally they will call on their colleagues outside to come and help put out the fire. So I think it was very, very key. It was a key moment for me, when I realized that there's actually real fires that are going on every day that, then these in-house teams are putting out. So I hope that gives you a flavor, Brian.
Yes, it does. And maybe if I also shared my own experience, I can tell you that I previously worked at a law firm, and I'm only new in the in-house sector for about 1.5 years. Maybe that's not very new. But I can tell you that one of the things that first hit me is the workload. Because when you're external counsel, you're pretty much looking for the client. But here you're in-house and the client, you have one client, which is the bank or the institution where you're working, and everyone is looking for you. They want answers in real time every single day. The pressure is just too much. So what I used to perceive of in-house counsel while I was at the law firm, I thought they would just be pushing paper. They would just be sending out these instructions to external people and having relaxed lives and chiller lives, only to get in and realize that it is a lot different. The workload is just crazy. And Andrew, I want to take us back to you and say, okay, let's turn into the realities of working within a large financial institution, right? Many external lawyers see only a small part of the picture. And yet in-house, you sit at the intersection of regulation, business strategy, and risk management. So to you, Andrew, from your vantage point at Stanbic Bank, what are the pressures that most frequently keep you awake or keep in-house counsel awake, regardless of whether it's within a financial institution or any other institution that the many people online and those that are listening in and with?
Yeah, thanks, Brian. And you're right. The challenges in a financial institution, large or small, or any other institution for that matter, are really the same. Okay, they might be, certain nuances here and there, and maybe you want me to speak to those nuances, but the challenges are largely the same. I think for purposes of, if you consider a financial institution, I think anywhere in the East African region or anywhere in the world, financial institutions are highly regulated. Okay, there is a raft of, I lose count sometimes of the raft of legislation that is designed solely, to regulate these institutions, and those are specific legislations, right? But you will have certain legislations that are cross-cutting that will, apply to any entity out there or even any individual out there. So I think the first, unique challenge that keeps in-house counsel in a financial institution is just the sheer amount of regulatory oversight. Now that comes with pressure, that comes with, reporting deadlines, that comes with, higher scrutiny. And of course, because, this is regulation, most of that pressure is going to be, dealt by the in-house legal teams. So I think it's important to highlight that. The second item that would keep in-house counsel in a financial institution, awake at night is reputation, right? As our external colleagues offer support, there is sometimes a tendency to lose sight of the fact that what is very key to in-house counsel is to be able to deliver a legal service while ensuring that the reputation of the institution at any given point is not, brought into controversy. I'll give you an example. If you are external counsel and you are doing a high stakes recovery litigation or a high stakes recovery for the bank, there's certain things that you are not expected to do, right? So it's not just about bringing back the money. The money is important to the bank, but what might actually be more important to the bank is its ability to keep operating, having obtained that money or having recovered that money. So I think those two items, in relation to, in addition to the usual thing, pressures, turnaround time and reliability and trust, I think for me what stands out is those two items: reputation, okay, and the breadth of the regulatory universe that financial institutions have to contend with. Thanks, Brian.
Awesome. I like that you speak about regulation, and we'll unpack that a little later. I wanted to invite Ahenda just to chip in here and say, Ahenda, from your experience, both in the fintech and in the banking environment, do you resonate with what Andrew is saying? And what's your experience? Are your pressures similar? Is it different across the board? Are the
Yes.
pressures same in Kenya and Uganda and all across East Africa? But more importantly, I would like you to speak just a little bit. What would you say are the different dynamics that external lawyers may not always appreciate?
Okay. Thank you, Brian. And yes, I do agree with Andrew. Working within the financial services industry does, have you dealing with not only just, your central banks as regulators, but there are quite a number of other regulators that you need to be cognizant of from a compliance and, like Andrew said, from a reputational perspective. There's also, your customer needs from an external facing perspective. But even as in-house counsel, there's actually pressure from your internal stakeholders because the market is moving quite fast. We are in an era where AI and digitization are actually moving financial services towards a different direction of travel. And that is what is actually, moving a lot of the pressure for in-house counsel. And given that internal, pressure and managing the internal pressure, the need to actually grow and expand the business versus actually, remaining and keeping your legal hat and your compliance hat and your legal risk hat on, just managing those two pressures can actually, keep you awake at night. On the one hand, you are expected to support the business, but on the other hand, you're actually required to also manage the pressures of compliance and actually also manage the pressures of, like Andrew said, remaining true to your ethical background, remaining true to your legal training, and remaining true to what you are called upon to do as in-house counsel.
I agree entirely. And I like that you speak about the business perspective, because you find majority of the time the legal element among the pressures becomes a little less, and sometimes the business element of the pressures can come with a lot of demand. Sometimes you forget you're a lawyer, and as Andrew was saying, you're the one putting out the fire, you're the one carrying the bucket, you're the one finding that last minute solution to an impossible task, and you're stuck thinking, when did I start to put out such big fires? Was I trained for this? Absolutely not. So Andrew, I want to get back to you and say, okay, in practical terms, how can these external counsel add real strategic value to your in-house problems, just beyond the legal opinions? And that's speaking from what you already said on managing the regulatory, the governance, and the business risks. Do you have any practical ways you think external counsel can add real strategic value? I imagine that those that are listening in, that's what they want to know, but mostly you that has been kept awake at night, you want someone that can help take some burden away from you. How would you answer that?
Yeah, I think, and this is probably, tired. It has been said time and again, but I think it's important to emphasize it. Understand the business of the client, right? Understand the business of the client. The moment you understand the business of the client, you are going to, because lawyers are typically brilliant people. They have the capacity to fit in any scenario and deal with it. But there's usually a tendency to get too concerned with the legalities of the problem. All right. The law is simply an avenue to create a solution. Now, the destination, or the actual spirit or the purpose of that journey is the business. Once you understand your client's business, you are going to craft your legal solutions to align with the business. So, and from my experience, again, crossing over, I used to imagine that, these institutions are very interested in having, these brilliant, precedent-setting decisions from the courts. Don't get me wrong; it's important to win court cases. It's important to score victories, but those victories have to translate into something of strategic value. Okay, so you'll be able to deliver as an external lawyer the moment you understand what the business is. If the business is a fintech, you understand what the crucial needs of that fintech are. If it's a traditional financial institution, you have to understand what is important to a financial institution. If it's a telco, you have to understand what's important to a telco. So I think first and foremost, external counsel have to understand the business of the client that they support. The moment you understand that, you are halfway there. Secondly, it is to create trust with your in-house partners. The moment I trust you as a lawyer, I will be happy to come to you even before crisis mode, right? I will come to you before a solution, rather before a problem materializes, because I know that I can bounce ideas off you, and you will be trustworthy enough to guide or to offer insights into how that can be resolved. Most times, and again, because in-house lawyers are first line defense, there is a lot of anticipation of crisis or anticipation of problems. You can know that a crisis is going to happen, but you do not know how to stop it or how to deal with it. So if you have a trustworthy colleague on the outside, and you have engagements, share thoughts, and then somehow come up with a solution, I can assure you that colleague will have you top, team will have you top of mind if a problem similar to that, or if a problem around that materializes. So when you create trust and relationships, and you reach out to your colleagues, I think it puts you in a position to offer real practical solutions to the colleagues supporting the institutions.
So Andrew,
and of course, the third one is sorry.
No, you can list the third one, but I wanted to interrupt you just briefly on the trust element.
Please
because
go for it.
I imagine that the young lawyers that are listening, or the external counsel that are listening in, are saying, okay, I do not have a relationship with Andrew. I don't have a relationship with Ahenda. I don't have a relationship with Brian. How do I even start to build that relationship? What does trust look like? What's the practical way to build the trust? Because you mentioned how you will give them a call, ask for their opinion. But by the time you even get there, it means you have something that has been ongoing for a while. You have the ability to call them in the middle of the night and tell them, hey, I have this crisis. What do you think?
Yeah, that's a very good question. It's also quite loaded, and I'll try as much as possible to unlock, to unpack it. I think the first element of trust, because as a lawyer, your stock in trade is your expertise, right? So I will trust you if you are competent. That's the first element, and there's no two ways about that. There's no debate about that. Because you are my good friend Brian, I'm not going to recommend that a high stakes matter be outsourced to you simply on the basis of the fact that we're good friends. You have to be competent, okay? If you are competent, then I trust that you will deliver a result that will be beneficial to the institution, right? The moment you establish that first line, of trust, then you're halfway there. What's the second one? The second one is reliability. I can be a very competent lawyer who is unreliable. All right. If I call on you in crisis mode and you are unavailable, if we have a court date and you show up late, if you attend court and adjourn a matter without instructions, or for a flimsy reason, you're tearing down the trust that ideally will be built. So to your question directly, trust, of course, you have to have an initial engagement with an in-house team, and that initial engagement is through an instruction being outsourced to you. So the moment the instructions are outsourced to you, that's your canvas to paint, right? You have a blank canvas to paint. You can paint it with reliability, you can paint it with unreliability, you can paint it with competence, or you can paint it with incompetence. So the moment you get your blank canvas, paint it by being trustworthy by being competent, and also too by being reliable.
Okay. Well, Ahenda, did you also want to contribute something towards that on any practical tip? Andrew, you
Yes.
also had a third element that you didn't mention, so I hope you remember to mention that. But let's just hear Ahenda, and then you can come back to you, Andrew. Yes, Ahenda.
Yes, thank you. I don't know if I'm audible. I see my
Yes.
internet connection is a bit unstable, but I hope I'm still audible. Thank you.
Yes, you are.
I think Andrew has made some very, very good points in terms of competence and in terms of reliability. I think the only thing I may add there is responsiveness. I think being competent and being reliable and to remain top of mind, I think, is to always remain. Andrew did speak about in-house counsel being like the first line of defense when there's a fire. And I think for external counsel to remain top of mind is to always be responsive. Sometimes as in-house counsel, the pressures that are there externally from customers, the pressure that is there like from court cases and jurisprudence that is being built out there does not afford us the time to come up with a very, complicated or, complex brief. But sometimes I just want to be able to pick up the phone and say, look, I have this issue and I need you on board. And sometimes that may mean I'm not giving you very, long or a very, what can I say, a complex brief, but that kind of responsiveness is actually what would be important for external counsel for you to remain top of mind. So it's not all the time that in-house counsel will have the time to actually sit down and explain issues. And I think this also goes to the point that Brian spoke about of understanding the business. So I think being responsive is also one key element of remaining top of mind, of being a trusted external counsel, just being able to take up a brief and run with it. And sometimes I see external counsel are very concerned about the billable hour. Sometimes the discussions on fee notes need to be taken at the end of a brief. I see Andrew is smiling. I think that resonates with both of you, coming from external to in-house. Some of those discussions, actually, we need the problem solved, and then now we can sit down and talk about how to pay the fees. So I think that attitude of being, very responsive, being very quick to act, I think is also quite crucial for us as in-house counsel to feel like you are the good or the right support to give us. Thank you.
Awesome. Thank you, Ahenda. Very, very relevant. Responsiveness was always key. I remember when I was at the law firm, some banks would call you in the evening and they want you to go and attend a case in Arua. Now, Arua, for those that don't know, in Uganda, is an 8 or 9 hours drive away from Kampala. So it means you'd have to set off that very evening and then figure out a solution along the way, but be there. And then once you build that reputation, then you have more work coming to you because they trust you to be the one to arrive and sort the crisis. Andrew, you had a third point, and then I'll transition to my next set of questions.
Yeah, and I'm grateful to Ahinda for talking about responsiveness. It's closely related to turnaround time, but I think it's more nuanced. If you are responsive, it means that when I call on you, I will trust that you will either take my call, or if you're not able to take the call because you are busy or you are handling a matter in court, you're going to call back. But I think the third, insight I wanted to add was be confident and take a position. Have you ever read, and I'm certain there are, among the colleagues on the call, there are some who are in-house counsel. Have you ever read a legal opinion that, in football terms, it's a draw? It's both here and here. So a lawyer is writing an opinion to you and asking you to essentially make the opinion. You know what I mean? I think it's important as an external lawyer, and again, that feeds into the element of practicality and being trustworthy. Take a position. We understand that it's an opinion. You're not a judge, and even if you are a judge, there are appellate levels. A magistrate's court, will make a decision which will be appealed and overturned at the High Court. The High Court, decision could be appealed and overturned at the Court of Appeal. So at the end of the day, your in-house colleagues are competent lawyers. They will understand that you rendered an opinion based on the facts that you were provided, and you took a position. Okay, the position might not always be accurate, but it's a position nonetheless. And we'll be able to take a decision based on the opinion. But you see, if you write 17 pages of an opinion, and then I have to decide what to do with it, then adding a lot of value to it. So I think there's need to be confident and render opinions that actually take real positions. Thanks, Brian.
Oh, well, now you touched on a very delicate subject right there, and I imagine the lawyers are like me, they are fuming. What do you mean we have not taken an opinion? I would really, really, really shun any legal opinion that is not pronouncing a proper recommendation, even if it is to your MD for the in-house counsel. Because I'll tell you one of the practical tips, and I know we're here for practical lessons as well. One of the practical tips we used to do at the law firm, as a rule of thumb, my former partner, Isaac Wakayana, he used to say an opinion cannot be more than 3 pages. So to have an opinion of 19 pages, what are you saying? It means you're talking about everything and not saying anything. So what are you saying? Because most times there is a crisis. Most times that opinion is going directly to the chief executive officer. Most times the head legal here may not have the time to read all that and understand. He wants to know, what are you saying? So one of the practical ways for those that are listening in is to actually start with what you are saying. So instead of the usual writing an opinion by stating what the background is, and then you have 3 pages of just the background, I already know what the background is. Get to the point, right? And then when it comes to the responsiveness, I also think the practical way of responsiveness, as Andrew has said and as Ahenda has mentioned, when you see that email, reply to it on site. Don't wait to say, okay, I've seen it. It was coming at 6 p.m. I'll reply to it at 8 a.m. tomorrow. Between 6 p.m. and 8 a.m. tomorrow, if I haven't heard from you, I'm going to give the instruction to a different person, depending on the crisis, depending on the urgency. If you're responsive, I know that you have seen it. Or if you call and say, hey, I've seen your email. This seems to be urgent. What's the plan? That's a responsiveness. So if you have an external counsel that has that mindset, that attitude, that sense of urgency, I think it goes a long way in building up the trust between the two parties. Now, I'd like to transition into the trusted advisor. And I know we've spoken a bit about the trust element. And one of the themes that often emerges when clients speak about legal services is the difference between the lawyers who simply deliver legal opinions and those who become trusted advisors to the business. And I know we've touched on this a little bit, but think about it critically, those that are watching and listening again. Are you just giving a legal opinion, or are you an actual trusted advisor? How do you get in there? And my question is to my distinguished panelists, from your perspective, and this time I want to start with you, Ahenda. From your perspective, what would you say truly distinguishes the lawyer who becomes a trusted long-term advisor from those who remain transactional service providers? They give you the bare minimum, and yet you have that one person who you would pretty much give all your work because you know that they get there. Let's hear your take.
Yeah, thank you, Brian. I think Andrew may have preempted my answer to this question when he talked about long-winded legal opinions. I think we really emphasize this point. We deal with a lot of moving parts and a lot of, conflict situations, both from an in-house stakeholder perspective and from, expectations from the executive in terms of delivering value within the business. And so one of the things that I really struggle with is just having legal opinions that are not really saying much and not really giving me value that would unlock an issue or would actually solve a problem. And it's not because that from the perspective of external counsel, I've always been in-house, but I think the perspective is always to protect yourself first. I think they always say trust but verify. And I think when it comes to delivering value that is strategic, that is long-term, that is sustainable, Andrew said it, you need to be able to take a position. But I think even to be positioned, you really have to possess some really good business acumen. You really need to be able to understand the needs of your client from a business perspective. From an internal business perspective, what are the things that drive the business? What are the things that the business is struggling with from a market perspective? From a regulator perspective, what are some of the issues that will actually drive this business forward? So being able to take a position and also being just and what the business needs, what strategic direction is the business going towards, what is the long sense of direction for the business. And I think that is very important to become a trusted advisor, just rather than being a transactional advisor on a case-by-case basis. If you want to remain top of mind, I think you need to be able to think about not just highlighting what the issues could be, but actually driving solutions for the business and for your.
Okay. So, Ahenda, maybe before Andrew comes in, just out of curiosity, I want to know, could you share from your personal experience, and you don't have to give names of who your trusted advisors are, some may be on the call, but paint the picture for us. What characters or habits or behaviors, or who would you, in your own many words or few words, describe as a trusted advisor, and what distinguished them? Like real personal experience that you've had. Yes, I am.
Thank you. I think we're navigating an era. Yes, are you able to hear me? Sorry about the internet connection, but I was saying, I think practical examples is I need, we are dealing with a situation. I think a lot of the in-house counsel who are working in banks right now are aware of the decision that was taken on Section 44. And there's a lot of pressure for banks to react to, pricing pressures in the market. And one of the issues that we deal with, even when we discuss with external counsel, is there's a push and pull between what direction jurisprudence has taken and the direction that we still have to deal with from a statutory perspective. So of the discussions I've had with external counsel usually point to actually just taking a decision and moving forward with it. I need to be able to call you to be able to give me that particular solution. Sorry, are you able to hear me?
Yes.
Okay, thank you. And I think from a practical perspective, is just having your thoughts on moving your thoughts from the paper to actually having that real conversation on the issues that we're dealing with on a day-to-day basis. So I think given that example of the jurisprudence that has been taken in Section 44 and just being able to come up with solutions that actually will drive decisions forward better for the industry. So I think that's an example I could give. I couldn't think of any other thing that was more practical than that live issue that is currently ongoing.
Okay. Well, maybe let me invite Andrew here to come in and also share from his personal experience. But Andrew, I'd also, as you chip in and share your personal experience, speak more about the professional habit that you think immediately would classify one as distinguishable from the others, and what habits do you think would sort of build confidence and inspire trust when you begin to work with an external counsel?
So, and I just wanted to emphasize what Ahinda was, submitting on the issue around solution oriented. Okay, it's important for lawyers to be solution oriented. I'm certain that in your lifetime you have engaged with lawyers who always seem to have solutions at in any set of circumstances. That's very, very key. Everyone, okay, maybe not everyone, but certainly if someone is good enough to be empaneled by an institution as a lawyer, then they are good enough to know the law. But ultimately, if that lawyer is solution oriented, that lawyer certainly stands out, okay, without a doubt. And two, there's the element of, because like you said, you have a lawyer who is just a transactional lawyer. Let me give you an example, and for my colleagues who are in-house, you can attest to this. You have, say, 10 law firms that are empaneled, right? You have an SLA with these law firms. Maybe the SLA is 2 years. If you do not outsource a matter to these lawyers, you probably never hear from them. The only time you'll hear from them is when they are saying, "Hey, Brian, I've not seen any instructions coming from your side. What's going on?" That's a transactional lawyer. That's a lawyer who is not creating a relationship or trust with the institution. On the other hand, there is a lawyer who, and remember, they participate in the same environment as the first lawyer I mentioned. But the second lawyer, whenever he goes to court or he participates in a stakeholder engagement, and there are certain insights, and there are always insights in those spaces that he or she feels will be valuable to his or her client, they're going to call you. And say, "Hey, I was in court and we had an interesting conversation with the judge, or the judge took a certain position on this on this point of law. I think it will be helpful to your institution. I think it is something that you should consider." You see the difference, Brian? So this latter lawyer is taking the initiative and adding value even where there are no instructions. You have not outsourced any matters to them, but they are prompting you and probing you and sharing things, because all these lawyers go to court. They all go for these meetings with regulators and other stakeholders, and they always get these insights. So when they do not share those insights and only wait for when they have a set of instructions, the position could have changed. But you see, by that simple gesture of reaching out and just saying, "Hey, the judge said this on the issue of spousal consent," or "the judge said this on the issue of stamp duty on transfer of shares," I think it will be helpful to your institution. Guess what? That lawyer will be top of mind when an issue like that comes up, because you will remember that it's Brian who actually told me about this thing. I think he's best placed to deal with this instruction or to deal with this matter. So that's, very, very key. And one thing I think the lawyers forget, the external counsel might forget, is that they have access to, say, 30 different sectors or industries, right? If you are in-house, you are lucky if your business intersects with all these sectors, but most times it's going to be specialized. Okay, so you might not have as much, breadth in terms of touch points with the different, legal positions and different stakeholders and regulators. So if you have these lawyers who are constantly communicating with you, it helps you to add value to the business that you support. And lastly, there is a need to anticipate challenges or issues even before they happen. You engage with certain sets of lawyers, and they're always thinking about what could affect a particular industry, or what kind of solution could best be tailored to that industry, even before these things happen. And again, that lawyer will remain top of mind when an issue like that breaks out. So it is, in my mind, it's those three qualities, of an external professional that I think would, be of significant value to an in-house set of lawyers. Thanks.
Fantastic. Thank you, Andrew. As you spoke, you really, really took me back to my days as an external lawyer. And while at the law firm, I was also in charge of business development. And it was my role to find out how can I get the business from the in-house counsel. So I did a lot of research and found out, what are people doing? What are the traits? What are the attributes? What are the characters? What is the competence that I need to acquire to be able to get the instructions from people on the other side? And I'll tell you that there are people who have done some crazy things in this Kampala, Uganda. I imagine it's the same all across East Africa. In one particular scenario, a lawyer was in court and he had a matter being called for one of the banks. And incidentally, there was no legal representation from the bank. So the judge called, anyone from this bank, anyone from this bank. The lawyer said, my lord, I am here. I've just received instructions. I seek a short adjournment to get acquainted with the file. Because the judge was just about to dismiss the case. But this particular lawyer had handled a different case for the bank, but he did not have these specific instructions. The lawyer thought it wise to stand in the gap, save the bank, call the bank and say, hey, I don't know who is the lawyer on this particular case, but I've just saved your day for today. I thought I should let you know. Do you know what the bank obviously did? They recalled the instructions from the other firm and gave it to this specific lawyer. That's a distinguishable trait. Now imagine you're within the court system. They call a case of a client that you already represent, only that in this specific one, you do not represent them. And then you let it slide, you let it be dismissed. Yet you could have saved the day. That's one example. Another practical trait that came to mind as you spoke, Andrew, and the Henda was, there's a particular law firm in Kampala where the managing partner made it a point to visit a specific bank every day, every single day, to come and say, hey, I'm just checking in. Do you have instructions for me? Every single day, even when there were no instructions, he made it a point to be visible. And after a while, whenever something came up, he would get instructions. And then there are others who, whenever they would visit, they would find, oh, I have this thing here. I've been looking for who to give it to, but now that you're here, the instruction is yours. I will be honest and say, even myself as head legal, I've also had those scenarios where a managing partner of a particular law firm has called and said, Brian, I'm coming over. I need to see what is happening. Why aren't you giving us instructions? And incidentally, I say, you know what? Come. And because of that pressure, because of that persistence, because of that being in your face, because of that proactiveness, right? And not waiting to be responsive, but rather proactive, taking the initiative, taking the greater mile. That gives you mileage in the in-house. Because sometimes people are not there dreaming, oh, I need to give so and so, oh, I need to give so and so. It is what is on top of mind. And it takes the initiative from external counsel to buy their way or to have footing into that mind of the in-house lawyer. So I wanted to park that there, and maybe I'll ask the people online, in your own wisdom, because I also want to engage you in this discussion. Just share in the chat room what traits you think a distinguishable lawyer is, or what traits you think you have been attempting to get, or what traits for the in-house that are here and would also like to contribute to the conversation. I think you could also just share tips. What traits you think external counsel need to know to be distinguishable. I've also seen that we have some senior counsel on call from all across the region. I think mostly maybe from Kenya. It's happy to have you here. So just share your insights and thoughts on that. Now, Andrew and Ahenda, I want us to move the discussion, because the discussion today could go on for days and there's so many topics and every topic could have its own schedule. But I want to touch on as many topics as possible and hope that they'll be relevant to our listeners and our viewers. So I'd like us to transition more into the future of the legal services, right? And I'll be asking the both of you. So, Ahenda, looking ahead over the next 5 to 10 years, how do you see client expectations of legal services evolving? I imagine that for the time that you've been in-house, they have definitely evolved. So if you could share some experience of when you think the expectations evolved from what you expected of external lawyers to what you expect of them today. And Andrew, I'd also like you to speak on that later. I know that some in-house lawyers and bigger institutions especially are moving more towards the technology and using more tech. So the expectation of external counsel is less and less. But let's hear your thoughts, ladies and gentlemen, starting with you, Ahenda.
Thank you, Brian. I think you have preempted what I was going to say. There's a lot of evolution of tech in the industry. And so we expect a lot of automation in some of the legal process flows, and we do expect our external counsel to keep up with the expectations of the market today. And given the evolution of tech, we also expect that at some point that our external counsel will also engage with with the technological advancements in the industry in terms of how legal opinions are even given. I think the other day I interacted with a legal opinion that seemed to have been generated by ChatGPT. I think even as we embrace technology, and perhaps this is something we might discuss going forward in this discussion, but even as we do embrace technology, there's an expectation that the legal thinking should not be watered down, or the actual understanding of the law should not be watered down. So the expectation is that even as we embrace these technological tools and technological advances, then we are able to just keep up with what is truly the integral purpose of a lawyer. I think the other thing that I see changing is that there's going to be a lot of specialization. I think we are moving from an area from an era where there's been a lot of generalist roles, even external counsel, to more specialized areas of law. I think that is something that has continued to happen even from when I was in campus and in law school. I think there's a lot of emerging areas of law that will require a lot of specialization and deeper knowledge in some of those areas. We are talking about, for example, the era of data protection. That is something that a lot of external counsel have needed to expand their areas of knowledge. We are again talking about AI and technological advances in the market. Cybersecurity, we are soon going to see a lot of expertise being needed in the area of AI governance, and that is something that our boards will need to grapple with, our businesses will need to grapple with. So I think specialization in some niche areas is what is going to be required by external counsel, because I think, Brian, you had said that external counsel, or sorry, it was Andrew, who had said external counsel have the advantage of a global view. So with that expectation, then I think specialization in some niche areas of law is what will be required, especially when it comes to the convergence of the tech and law and where we are going in terms of the future of practice. Thank you, Brian.
Awesome. Thank you. I like that you introduced the aspect of specialization. But first, let me hear Andrew's comments. Do you agree with Ahenda? Is that the same on your end? How does the future of legal services look like within Stanbic Bank within the Ugandan context?
So maybe I don't want to lose my train of thought on a point that Ahenda was making in relation to specialization, okay, and the shift away from generalists. In my view, it's a mixed bag. It is true that any institution would want to engage with a specialist, okay, or of some sort, but that because you can only have so many specialties as an individual. So I think there's an opportunity for external lawyers, or any lawyers generally, in that you can create a firm of very many specialists, all right? And then you end up having a law firm that is a generalist, but when you peel away the layers, it's actually a firm full of specialists. So I just wanted to point out that there's an opportunity right there. Even as we're moving to more specialization, there's an opportunity to create a generalist firm, but with a large pool of different specialists. Because again, with technology and AI, there's all these innovations that are coming up. Lawyers are advising on things that they never advised on 10 years ago. So there's literally an opportunity for people to be specialists in almost everything. Now, as an individual, one might not be able to, pack all those specialisms in one head. So they might as well, get a collection of brilliant people who are then specialists in those different areas. But where do I see the future? It's one of those, especially when you speak of AI, it comes with its own good measure of depression. But I think one thing we have to be aware of is that there is a push for cost optimization. Lawyers are now being judged by how well they optimize cost, right? You cannot, and I think everyone can attest to this, the size of billing, the size of invoices, keeps going down because there are more efficient ways of doing things. I think it's a natural progression of any industry, but that should not be gloom and doom for the lawyers, because there is possibilities then there to reposition and recreate how professional services are offered away from the traditional. Because I think lawyering is one of those professions that is so stuck in its ways that everyone else around is changing, but the law has, or at least the culture of the law has not moved 1 inch. I think you can see from how we write letters and demand notices. I think it's the same way that they were written in the 1800s, even with English that is not used anymore. So I think there is a need then for lawyers to reposition themselves and find creative ways of driving value for themselves, but also for cost optimization on the part of the client. There's going to be a trend of moving lawyers away from routine support. Okay, if you're following what these AI models can do, you can tell that they are taking over, work that is say elementary. Things like authoring of demand notices, authoring of letters, and other mundane tasks. So what does that mean? It then means that in the future, or the future lawyer has to be able to handle complex matters and move away from the routine solutions. If I can use Uganda as an example, lawyers used to make money from company filings and company registrations. That has been taken away by these platforms that are then embedded into clients. Clients can now do these routine filings on their own. So it has eliminated a significant portion of lawyer involvement. So what that means in my mind is that the future is going to need lawyers who are able to just take away all the mundane tasks, probably automate them, and then take on significant, complex transactions. Of course, that speaks to upskilling oneself or your teams, but it's one of those things that I see happening. The beauty, of course, with technology is that there is now an opportunity to more than ever do cross-border lawyering. Previously, I think an engagement like this would have had to happen somewhere in Mombasa or, somewhere in Kigali, but we're having it here. So it means that these lawyers have the capacity to engage with in-house teams across the board. So whereas there's doom and gloom, it's not all doom and gloom. There are opportunities for lawyers in the new way that the law is going to present itself, and then the lawyers have to be nimble-footed enough to position themselves and anticipate those changes. But lastly, and I think which is very, very important, is the future of lawyering is going to move away from this knee-jerk reaction, right? An incident happens or a risk materializes, and then the lawyers come running to deal with it. I think the future lawyer is going to be one who can anticipate these things even before they happen, and that makes that lawyer more valuable, because then your insights will be greatly appreciated by these different institutions, and they will know that Brian is an insightful lawyer. If I have him in my corner, I will always know what is coming, around the bend even before it happens. So there is a need. The new skill, I think, is anticipating, because we're living in a very dynamic world. So being able to anticipate new challenges or unforeseen challenge is going to become a skill that is not only a good to have, but one that is a must to have.
Wow, there's a lot to unpack in there, and for the people that are watching or listening again, I really hope you're taking notes, because I'm here taking notes, and I just want to break it down for you. Okay, what I hear Ahenda and Andrew saying is, we need to think future. Now, the bulk of us, if not all of us, are lawyers, and I know there may be some non-lawyers here on the call, and we're thinking, what's the future of the legal services for the in-house lawyer? What's the future of the legal terrain? The relationship between the in-house and the external. We cannot ignore AI. We are living in the AI revolution. AI is not here to take away your jobs, but how are you scaling for AI? We all know that today the lawyer that knows how to prompt, that knows the large language models and how best to utilize them, that knows the AI tools and how to relate with them, that can interpret them such that in case of the dispute, who shall we call on to represent us as in-house or as financial institutions or as large institutions that are across East Africa? So if you haven't distinguished yourself as one that even knows the bare minimum, the bare basics of AI and how it operates, then this work is never going to come to you. But guess what? The law firms in the UK and in the US specifically have actually developed their own AI models. Majority of the law firms are doing their AI tools that are helping with contracts, that are helping with reviews and analysis of bulky documents, huge text, cases and precedents, digest. So recently, while attending one of those conferences on AI, the lady told us that AI is for doing, not for thinking. So if you're using AI for thinking, you're doing the wrong thing. AI, you prompt it to do. Now, if lawyers can start to think that way, they will be a mile ahead of the rest of the pack. So give it the prompt, give it the information, give it the data, and ask it to do. But do not ask it to think for you, because that's where you go wrong. And if you're giving an opinion, some of us are already skilling in siphoning and sniffing out an opinion that is written by AI. Ahenda here has told you that I think she's interfaced one. And if I, as an in-house, saw an opinion written by AI, at the very least, it had better be the right opinion. If it comes with errors, we all know that AI has some hallucinations, some things that may be fake, and some things that may not be as relatable to the business. So you need to think futuristic, ladies and gentlemen. In terms of specialization, from my own take as in-house, maybe what I would advise is, yes, I've seen lawyers who have gone the extra mile to put themselves out there as forward thinkers. So whenever something new is happening, there's an article, there's a piece in the newspaper, or there's an email, there's a newsletter. They're letting you know that this is happening around the world, and this is how it affects the industry. This is how it affects people that you work with, your suppliers. Please take note. They're being proactive. They're not sitting back and hoping that we shall remember them, but they're giving us these free of charge legal services. So what's the value add for those that are external and are thinking of coming internal? You can start to do simple value additions like those without being paid, because it's information, it's support, it's an alert, it's a report here and there. It's, by the way, have you heard? Do you know? This is coming out. There is a bill that is being discussed on mortgage refinancing. It has actually been made an act. How does it affect the entire banking industry? So it's good for lawyers that are listening to be proactive. Now back to our chat room. I see Edwin was able to share the traits. Thank you, Edwin, for reminding us that some of the distinguishable traits that make lawyers stand out is expertise, trustworthiness, proactiveness, good communication skills. Ladies and gentlemen, is as important as it is. Have you ever received an email from an external lawyer that has typos, or that has no subject, or that has things that are very basic? To be honest, they elude trust. They destroy it the moment I see it, and I may not even bother to reply to it. Understanding the client's business, Edwin, there you were spot on. If we perceive that a lawyer doesn't understand our business, and every time we explain to them, they seem to think they know it better than we do, or they think to propose things that do not make sense or cannot be applied in our business, the trust is being eroded. The reverse is true. If they know what they're saying and they help us find solutions long before we ask, that gives them great mileage. Okay? So my panelists, again, I know we've spoken about the future, and the future is a bright one. I just wanted the two of you to speak about what do you think the advocates should start to do if they want to future-proof their practices in a rapidly changing legal and business environment. I know we've hinted on this, but maybe you could give some practical tips. Ahenda, what do you think the lawyers listening should do to future-proof what's coming? Can you give them an insight into how your organization is thinking, and tell them, by the way, if you guys are not thinking this way, you are not future-proofed?
Yeah, thank you, Brian. I think two things stand out for me, and it's something that Andrew spoke about. I think we are going to continue to speak to each other's points as we continue with the discussion. But he did speak about being able to remain anticipatory of issues as they arise. I work in the regulatory affairs space, and that means my job is constantly trying to anticipate what regulators are thinking and what risks they are trying to, mitigate in the industry. And my first point of call is an external counsel who's aware of, some of these issues that come up. So being able to anticipate some of these risks, especially in the regulatory space, being able to try and have discussions with me as an in-house counsel on what some of the issues regulators are covering. I saw the other day that the CBK and NBR Bank of Rwanda actually are, thinking about passporting framework. That's something that can be really advantageous for in-house counsel. Kenya recently passed the Virtual Asset Service Providers Act. The regulations are now in play. And like I said in my earlier discussion, that we need to be able to anticipate where the business is growing, what is the direction of travel to bring value for customers. And that means innovating in the digitized space. And so an external counsel in this space, if they're able to, sort of anticipate, for example, having a discussion on what type of regulations may come out, what restrictions, what leeway will the regulators give us in terms of innovating in that space? Because as a bank, as a regional bank, and that is a leader in that space, we do not want to be left behind when it comes to innovation. We must play in the market as well as the fintechs are playing. So external counsel must be able to, anticipate that for us and give us that advisory from a predictive point of view. And I think the other thing that both of you have touched on actually on innovating in the space of invoices. I think, like Andrew said, we're really contracting when it comes to getting invoices and looking at invoices that are really heavy on the billable hour. I think we need to get into a space where that partnership changes from the perspective of just looking at it from I billed for this many hours and this is how long it took me to do this opinion. Let us also have a partnership where we're looking at evolved retainers, where we are able to have a long-term relationship that is more sustainable. I think that would make sense for a lot of in-house counsel. And it makes your relationship longer with the in-house counsel and with the institutions that we'll be supporting. So I think just top of mind, that is what I would say.
Thank you. Andrew, very quickly, and then we'll move to the next. I know our time is pretty much running out, and yet I want to involve the audience with more questions.
So thanks, Brian. So top of mind is to, everyone is worried about artificial intelligence. Everyone is worried about the internet, and but there are opportunities there. One, so we can use that to also, create advantages out of it. One of the ways is by just, being able to distinguish yourself by understanding how to use these tools. I think, Brian, you touched on that earlier. But because these are new things, then I might feel safer or more confident with a lawyer who knows their way around it. Okay, so it is key. And then the other one is around building of synergies. So because there is pressure on fees or cost optimization, the traditional billing is not going to cut it. Where you perform an instruction and then you bill, it may not cut it. So the lawyers have to be able to now become creative in how to drive value. Again, like I stated earlier, lawyers have access to different stakeholders that some businesses might not have, So if you can build on your relationships with those stakeholders and drive value to your client, okay, you will be looked at as a partner as opposed to, a lawyer who is charging fees. In fact, if you wanted, you could even, monetize such capability or such contacts. For instance, if you do, work for, you represent a financial institution. What does a financial institution do? What are the pressures on its business? Can you unlock those pressures? Do you have international contacts? You have affiliations with international lawyers and whatnot. How can they add value to your client? Okay, as opposed to, let me wait for Brian to send an instruction, right? We, I've engaged with a set of lawyers who were doing a big deal. I think they had clients coming in and they were setting up a solar plant somewhere in the western part of Uganda, and they were getting financing from abroad. But when they got here, these lawyers told them, no, we have an institution that can arrange, this financing for you specifically for the model that you are trying to set up. So you can imagine how easy, that conversation was with the business executives and how they were perceived as professionals. They were looked at as partners as opposed to lawyers who are just waiting to dole out a bill, and so I think that's one of the ways that the law firms can then future proof. Thirdly, maybe which is quite crucial, is living under the existential threat of artificial intelligence taking over legal jobs. I think then lawyers should pivot on human skills, right? That can't be replaced. A chatbot is going to, review a contract in 3 seconds, fine, but it might not give it real life nuances that a natural lawyer would have given, in a set of circumstances, and it might not be able to add a personal touch or personal value to the client in those circumstances. So then the lawyers should pivot on human, emotional intelligence to as the cornerstone of their practice, because that is still very, very key. I'll give you an example. I don't think very many people would trust a chatbot to handle a custody dispute. Why? Because in a custody dispute, you're engaging with someone who has, you want to engage a lawyer who has certain values, certain, emotional awareness about the rights of a child or whatever it is, or just the circumstances of such a scenario. So I think there is value in pivoting on human emotion to be able to make it in a cornerstone of your practice going forward. Another one is turnaround time, right? If chatbots are doling out opinions in seconds, we cannot afford to take 2 weeks to render opinions or to render a routine advisory. So I think then the pressure is to then be quick on the time in which we turn around some of these instructions. But then again, you can do that while pivoting on these tools. They improve your turnaround time. So you use the tools to make your turnaround time, superior, because the world we're living, the world that we're going into is dynamic, and decisions have to be made on the go.
Thank you, Andrew. Very, very relevant, and I hope you are indeed taking notes. I also ask the people that are online to please continue to share those questions, because we'll be coming to the Q&A section shortly. I like, Andrew, that you mentioned the being perceived as partners. For me, I think that's one of the best way to future-proof yourself as external counsel. If as in-house, I look at you as a partner, or if the institution looks at you as a partner and not as a lawyer that is an expense, but one that has actually created value, one that has brought money into the organization, then that's one sure way of future-proofing yourself into more business with the institution. Now, Henda, I want us, as we try and wind up, and I know we're already at 3:30 and this runs up to 4 p.m. We'll try and keep within the bracket. I want us to talk about the general client career advice from the side of the client, okay? And we know we have a bulk of young lawyers that are listening in, streaming live online. So from your experience in both the fintech and the banking environments, could you speak to a young lawyer on what could be the best way for them to earn credibility with an in-house team and how to distinguish themselves from those that are struggling? And while you do that, could you just also speak about what's the one essential skill that you think they need to master to remain relevant to the in-house arrangement, especially handling regulation, technology, and very quickly evolving business models? So let's have the discussion tailored towards career advice from the client side, especially to the young lawyer. And I believe they would appreciate as many practical and real-life examples as you can.
Yeah,
And
thank you. Thank you, Brian. I think I may have hinted at this when I was speaking about legal opinions that are generated by AI. I think we cannot ignore the current environment that we are operating in, and young lawyers are now getting into a field that is quite diverse, and there's a lot of pressure to make a name for themselves in the industry and to advance their careers, which is understandable. But I think one of the things that I will continue to emphasize, even for those that I work with directly, is that you must always remain credible, and being credible means that your work can stand against a stress test. Meaning, your work should not hallucinate in itself. I think the one skill that should remain true for any lawyer at any level of their career is that you must always be a champion of research. I don't think we can separate ourselves from having to learn and to continuously learn in our various fields, in our various sectors that we operate in, whether you're in-house, whether you're external counsel. And I think for young lawyers out there, even as you engage with this new tools in terms of making your work more efficient, making your work faster, I think that the one thing that will always remain true is that you must always remain curious in terms of, researching. I think it's also very important to put yourself out there and engage with your seniors in the field, look for mentorship opportunities, always be curious to learn from those who are in the industry that you're looking to get into. I don't think you can really learn when you're just behind a desktop or behind a laptop. I think it's very good that you actually look for mentorship opportunities, look for opportunities to actually, if they do come along, job shadow if you're within an external firm. Be curious, don't be afraid to be sent. I think young lawyers nowadays are very afraid of what we call being patient. I think there's a microwave attitude towards growing in the career, but I think it requires a lot of patience. It requires a lot of resilience, and just being able to, pace yourself as you learn and as you grow. So I think, parting shot for me to young lawyers, do not forget to think and to remain curious. I think look for the mentorship opportunities, be willing to learn, and just be willing to actually just grow in your career progressively. Thank you.
Oh, thank you, Henda. And I thought you'd also speak to, if there's one way that you think they should distinguish themselves, what's that one skill that you think, if a young lawyer showed up and they were exhibiting this skill set, despite their young age or their inexperience having served the institution before, you'd really consider them favorable?
I think the willingness to learn, I may not have really pointed out to it, but I did say, very clearly that, I think the willingness to learn, when you're a young lawyer, you should be a sponge, being willing to absorb and, having that curiosity to actually grow within within whichever field that you've chosen for yourself that you want to grow in, that willingness to learn. So there's what you have learned in law school, but I think the practical experience, that is something that will always come over time, and you have to have that willingness to learn and the patience to actually do it.
Fantastic. Now, for those that are listening in, if there's anything I'm hearing Ahenda say, and she uses these words like sponge, like trying to avoid being a microwave generation. Someone actually called it a popcorn generation because you want pop, 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 pop. You want answers, you want them quick, you want money, you want it quick, you want instructions, you want it quick. You want to be the best law firm servicing the best, highest possible institution in the country, and you want it now. No, it's not going to work. So these mentorship, learn as much as you can, show the willingness, show up in these spaces, make the relations, rub shoulders, build your way up, network with the right people, not anyone. Back to you, Andrew. I want to know what your advice would be to these young lawyers in a more practical way. What's the career advice you could give them? If there's anything that's keeping you awake, they are also being kept awake thinking, how do I get into these spaces? How do I get instructions from these institutions? How do I earn my...
Yeah, thanks, Brian. Every time I'm asked that question, my response is usually the same, and I'm going to maintain it for this session as well. So, any lawyer who is on this call or who is watching this is already halfway there. It's they are going to make it. They are going to do well. Otherwise, they will not be able to be in this space. So, and maybe to Ahenda's point, they needn't worry so much about their survival. Okay, that will come. However, one attribute that they should not dispense with is being credible, having integrity, and just being upright professionally, in whatever they do. The reason that is important is we are living in a global setting. We are living in the age of the internet, and you know what they say about the internet, it never forgets. You ruin your entire career when you engage in dishonest practice. And that is the end. If a lawyer was caught on the wrong side of the law, you would find out, the public would find out if they bought a newspaper or if they followed proceedings from their respective law councils, right? And you can imagine very many people do not buy newspapers, or very many people do not follow proceedings of the law council. So a client might never know the kind of reputation that a lawyer had or has. Right now, everything that you do is going to be put on the internet. Records are going to be uploaded to the internet. A simple Google search against the name of a lawyer would reveal much more than one asked for, and that is indelible. It's going to stay there forever. So my advice to young lawyers is to protect their reputations with all that they have. We are lucky as lawyers that we have a very long career. It's possible to practice as a lawyer until you are 90, right? I know senior counsel in Uganda who are 90 and they are still, running practices. Maybe not at the same vigor as they used to, but they are still running their practices. So imagine being robbed of a career at 31. That means you've lost 60 years of a livelihood, right? Just because you wanted to to wear a shoe from Oxford Street in the UK. So it's yeah, and the shoes from Oxford Street are really nice to look at, but that shouldn't be at the expense of 60 years worth of a livelihood, right? I think for me, if a lawyer understands that the rest of the items, they'll be able to learn them. They will learn the law, they will master, they will specialize, they'll do all these things. But I think the campus should be integrated. What feature would I like to see in a young lawyer, or what feature do I think is going to be valuable to a young lawyer in the future, in the world that we're living in right now? I think it's being adaptable, right? It's being adaptable because the world is moving so fast. You cannot afford to ground your practice in land conveyancing alone, right? Tomorrow it's going to be Bitcoin, the next day it's going to be, all these sorts of things. So the ability to be open to change and being adaptable, and I think is going to be a superpower. So all young lawyers, and of course we as lawyers, we are typically conservative and whatnot, but I think the future lawyer has to be so adaptable, because it's in that being adaptable that they'll be able to harness all these opportunities that are seated around us. I hope that answers your question, Brian.
Yes, it does, and I like that you speak about integrity and adaptability. When you spoke of integrity. Oh, but first, before I forget, I wanted to make a comment and say, I think, Andrew, I've seen you with a shoe from Oxford. I will come and inquire how to get one myself. A good lawyer should look nice. That was just for jokes. When we speak about integrity, I need to speak about this because my role, I actually have dual roles, both as head legal and as company secretary. Now, the company secretary part positions me as a governance professional. And I'll tell you, for the external counsel listening in, that governance is a big thing today for any institution that wants to live long beyond its days. Because governance is all about sustainability. It's all about being a corporate citizen. It's all about systems and ways that can outlive any succession plan. So if you want to be relevant, you need to show the same. You need to start applying governance, policies or themes or practices within your own law firm. You need to show that you're not a one-man law firm that can crumble if you showed up sick or someone else represent the institution in court. But more importantly, you cannot risk your integrity, because for the bigger institutions that are very keen on governance, that are very keen on international standards, that are highly regulated, not just nationally, regionally, internationally, they have partners that are holding them to the highest standards. If any news came out saying, look here, one of the lawyers on your panel was caught in a gold scandal, that's a threat to the business of the entire institution. You are a threat. So one of the goals, even for the young lawyers as you're trying to get into the market, is to never be the threat, to never be the risk, to never be the weakest link, but rather look to how you can support the institution, promote its reputation, promote its sustainability, promote its business to beyond its years. Okay? Now, our time is quickly running, and I know this conversation could go on and on. I like it. I love it. I want to give a chance to whoever wants to ask a question, and maybe Gabriel and team from the East African Law Society will help us coordinate and maybe give at least one or two people an opportunity to unmute and ask a question. But while they put up their hands for you to coordinate that, I have two questions in the Q&A section from both anonymous attendees. They did not disclose their names. But one is asking that on the issue of visibility, I note that in-house lawyers tend to give work to lawyers they have worked with before. How can young lawyers how can young upcoming lawyers show they can bring value to in-house lawyers before being given a brief? I think we've touched on that, but again, maybe we'll clarify on it with my panelists. The second question is, how true is it to argue as follows? It's great to do all that proactive stuff and whatnot. This works in an ideal system, but what is not being discussed are the informal and, quite frankly, on the edge styles of creating relationships with an institution. Getting into panels is one thing, getting briefs sometimes depends on the willingness to pay back, in quotes. This is the unspoken tactic so prevalent in the cutthroat practice arenas in some practices. My fellow panelists, what are your comments to these questions? What would you say? Is it true? Is this a way of life? Visibility, how can people be more visible? If you could just quickly respond to both of them, Ahenda and Andrew. Please do raise your hand, and then we'll also give you an opportunity to ask live. But for now, let me give Andrew and Ahenda a chance to respond to those two questions.
Yeah, Brian, can I take those two questions? I think, and I resonate with the young lawyer who is wondering how are they going to get onto a panel, how are they going to have that initial engagement with an in-house team, and how they're going to be enrolled onto a panel. Those are very, very valid concerns, and it's typically the dilemma of a young lawyer. I think my advice to young lawyers has always been, it's not important to reinvent the wheel. What do I mean? So I'm imagining if someone says they're a young lawyer, they're probably maybe 5 years out of law school. Do not burden yourself by leaving law school and then 5 years in you are setting up practice of your own. You work with someone who is experienced. That person is going to do two things. They are going to show you the ropes of the practice, but more importantly, they are going to introduce you to clients that you might have never had access to. I'll be frank with you, and I think Ahenda can, bear me witness. If you are 5 years out of law school, you do not have a reputation, it's very unlikely that you're going to get onto a panel of a credible institution, right? These institutions have a myriad of corporate governance that virtually makes it impossible for them to deal with professionals who are untested, right? It just doesn't work. If I was to flip the question, if you are a young lawyer and your firstborn daughter, has a severe complication that needs a medical, a neurosurgeon, for instance, I do not think you're going to take your daughter to a neurosurgeon who is 2 years out of medical school. You will want to engage with a neurosurgeon who has a reputation, who has some experience of saving lives. Okay, so it's the same with these institutions. They want to engage with lawyers who are credible, who are reputable. So if I was a young lawyer, I would try as much as possible to work under the tutelage of an experienced lawyer. That lawyer has credibility, they have worked for it, and I will engage. And we have been there. Brian, I'm sure you had certain matters that you used, that Mr. Bakana used to take you along, and then within a few years, the lawyers began calling you directly as opposed to calling Mr. Bakana, because you at that point you've demonstrated capacity and you've created trust. So there's no shortcut. You have to earn your stripes. You have to earn the reputation. You have to put in time. So the answer to the young lawyer's question is yes, it's a challenge as a young lawyer getting onto panels, but there are ways around that. Work under the tutelage of an experienced lawyer. You will get there inevitably if you are a good lawyer. And then to the second question, I think our colleague was talking about probably bad practice of instructions that are not, given out on merit, but they are given out for, I don't know, kickbacks. And I will that my answer to that is very, very blunt. That's not proper, that's unlawful, and most of these institutions have capabilities to sanction that. So, and I want to imagine that, if those practices happen, they are typically in the exceptions, but generally, most of these institutions, especially the credible institutions, have democratized, how they instruct external counsel. I'll give you a personal example. It's a compliance function to ensure that there is no concentration risk. If I have a panel of 5 law firms, there is a dedicated team in the bank that is going to question why only one law firm is getting the instructions, because it introduces risk to the institution. What if that one law firm folds and it's handling all the briefs of the institution? So I want to imagine that the more progressive institutions have checks and balances to ensure that the practice that is being insinuated is dealt with and is stamped out. Thanks.
Thank you. Ahenda, you want to give a remark on the questions? Please, ladies and gentlemen, those that are with us online, please do share your questions in the chat room or in the Q&A, or if you want to ask a live question, raise your hand and then we'll unmute and give you a chance before we close. Yes, Ahenda.
I think Andrew has really covered them well. I fear to be repetitive of what he said, but he did make a very important point on the bad practice that is insinuated by the question. I think for those organizations and institutions that have proper governance mechanisms and governance processes around them, he did speak about concentration risk. And I would just like to add that actually a process of empanelment for a lot of these organizations based on ethics, based on the knowledge of the firm, and also based on the strategic issues that the institutions are currently facing. So I think just to add on to what he said, not to water down his point, but I think it's very important to recognize that these institutions actually have governance mechanisms around them. And some of this, actually not some, the decision of empanelment just doesn't rest with the in-house counsel alone. There's an actual structure around how those decisions are made and actually how efficient or how sustainable the process is. Thank you.
Oh, thank you very much. Well, let me do the asking because I had. Okay, I think I see a question on the chat room. Oh, it's a long one. Okay, Gwenja Alex is asking that when I hear cost optimization, it often suggests the value of legal services is not fully recognized. During COVID, lawyers were not even considered essential workers, which says something about how the profession is perceived. We therefore need to be deliberate about staying at the value table, ring-fencing legal work, and avoiding underpaying lawyers. That undermines our profession. My concern is that some in-house lawyers gradually shift loyalty from the profession to the companies they work for, and in some cases even end up working against the bar. At times, it's in-house counsel who spearhead cost-cutting measures in a bid to please the employers while the company is the client. The question remains, which comes first, the profession or the employer? As lawyers, we must still safeguard the value and integrity of the legal work. I believe he's speaking about fees, and fees can also be a delicate subject. It's prompting us to continue to look to the sustainability of the profession as the key, and maybe we'll address that in a minute. Allow me to ask it jointly with the question I had for the two of us as we wrap up, Andrew and Ahenda. And I would like you to speak from the client side, and hopefully you'll also speak into the question by Alex. What would you say are the mistakes, the preventable mistakes that external counsel make when working with an organization like yours or any other organization, including those organizations that you previously worked with, And if you could wrap that up with a final closing, and speak to practical advice to the lawyers listening in. What should they start doing, stop doing, and continue doing for the purpose of building credibility with in-house counsel? So my panelists, if you could speak to that, and then we'll finally have the closing remarks, that would be a fantastic use of time. Over to you. Who wants to go first? I've given you the freedom. All right, Ahenda, let's hear you.
Ladies first. Huh?
Ladies first, thank you.
A
I
friend used
think
to say ladies first and letting men go first. But over to you, Ahenda.
Thank you so much, gentlemen. I think it has been a very engaging discussion. I think we need to have a version 2 of this. But I think as we wrap up, one of the most common and preventable mistakes, I think, might be a bit sensitive, but I think a lot of external counsel do not actually just admit when an error has been made. And I think it is Andrew who said that even as in-house counsels, we are experts in our own rights. We are able to identify some of these issues when they do come up. So from where I sit and my perspective is that we are lawyers to be able to solution build and come up with solutions for the business and for the clients that we work for, because as in-house counsel, my client is the employer. But I think as external counsel, I think there's a certain tendency to sort of try and cover up or hide errors when they do occur. We are human, that usually happens. But I think if we take the stance that we are partners in solution building and in solution finding, then I think that transparency is important for us to be able to achieve the best possible outcome for the single client that we have, and that is the institutions that you have been given instructions for, and my employer as an in-house counsel. So I think just being able to be transparent and having that solution building is very important. Then trying to imagine in a situation where you've made an error and it's a court case and you're actually making submissions before court, then we're not able to actually arrest the situation in good time and actually come up with a positive outcome. I think the other issue I come across a lot is that assuming all your clients are the same, just because we are all banks or institutions that have the same business goals or business models, then it boils down to what your client perceives as a win. Some clients do, or some institutions perceive wins as precedent setting matters, but for other clients then it might be cost efficiency. So I think that assumption that all institutions do approach strategic wins the same is maybe not the best practical approach to how you have clients. I think just understanding what a client views as a win is very important, and not the same assumption. I think in terms of what external counsel should stop doing is, like I said, hiding errors. I think continue to provide value add services. That is very important. I think Andrew spoke about being able to predict that, for example, the direction of travel when it comes to matters, being able to just provide insights. I think that is something that should continue. And I think when it comes to start doing, I think I think it's both of you gentlemen spoke about, but trying to look into niche areas of practice and expanding your practice areas to actually cover emerging areas of law. In a nutshell, that is what I would say.
Thank you very, very well articulated. Over to you, Andrew.
Yeah, I completely resonate with Ahenda's insights. I think quite important points. I think I would add to that that the biggest mistake an external counsel can make is to have a misaligned understanding of what the client wants or what the solution to the client is. When an institution reaches out to an external counsel, they have a problem, and usually the problem is one that is a threat to the business. So the response to dealing with that problem must be aligned with the business. That does not mean that the institution is asking the lawyer to be a yes man or a yes woman. No, no, no. The business is saying, this is our problem. Is there a solution? If there is no solution, is there a way around it? Okay, so then that calls for a lawyer being creative in coming up with solutions. It very unlikely to be like for like. This is the problem, this is the solution matched. Most times it will be a solution that might not be entirely the solution to the problem or to the way the problem was presented, but it could be a creative solution of arriving at the same destination. So, but I think the important thing there is to make sure that you are aligned with the business. You want to understand what the business wants to achieve, and then you work backwards. We lawyers have a tendency of wanting to possess all the answers. Okay, but sometimes those answers are not relevant to the client. So please hold off on providing solutions the way you think they should be provided. Listen to the client. What does the client want to achieve, and then work backwards. That's I think that's what makes the difference between a business-oriented or a solutions-oriented lawyer from an academic lawyer, because I'm sure you've engaged with briefs or opinions that are so academic that you wonder if they can be put into practice. So I think that's the mistake that most external counsel make. What not to do? You see the relationship between law firm and institution, whereas it's a contractual relationship, it's also a human relationship. There are individuals behind those law firms. There are individuals behind these institutions. So as much as possible, if you make it more personable as opposed to more transactional, the better. That's how, because I have met you and I've explained my problem to you before you even tell me what solutions or how you're going to provide the solutions, in what timelines. You are already, talking about fees, and fees have to be paid. But any institution worth its salt will pay fees, right? But when you front fees, you end up killing the relationship that would otherwise have been created. I know law firms, for instance, that sometimes even pre-fund disbursements, right? Because an institution typically will have very many governance frameworks through which funds can be disbursed for a lawyer to do work. However, I have someone has filed a case against the institution. It's a Friday evening. The institution wants an injunction to be lodged immediately, and the lawyer is telling you, I cannot lodge that injunction application until I get paid, right? But you know that this institution does not have money lying in a box somewhere. It has to go through the approvals and whatnot. So I think a lawyer who has emotional intelligence will be one who will first create a solution and then say, hey, I did this and this and this and this and this. This is my bill. And at that point, you've already warmed your way into the hearts of the people behind the institution. So don't be transactional and robotic. Have empathy, have emotional intelligence, create relationships behind those institutions. Continue doing. The lawyer should continue. I think I entirely agree with Ahinda that they should continue building value outside the core mandate that they are being instructed to do. Create value addition, whether it's trainings, whether it's insights from the industry, whether it's relationships that you think can be helpful to the institution. bring a full package as opposed to, simply acting like a mercenary. Thank you.
Well, very, very rich takeaways, and I hope that to our listeners and attendees, you have taken lots of lessons on what you should start doing, what you should stop doing, and what you should continue to do. Now, to my panelists, I will have one final question and then also make my final remark. If there is one takeaway that whoever has listened in, what would you say is the single most important thing that lawyers should remember about how clients think and make decisions? Because that's the purpose of today's conversation. What would you say that single most important thing that lawyers should remember about how clients think and make their decisions? Ahenda.
Maybe, Brian, before Ahenda comes in,
Yes.
may I request, I see that Alex has a question that hasn't been taken in the chat. He had a very, very long question. I can attempt it. I can attempt the question because I think I understand where Alex is coming from, and I think Alex is like us. He has had a stint on both sides. In fact, now for him, I think it's the reverse, and he makes a valid point. I think lawyers must jealously protect the fees that they earn because that's a livelihood. Okay, but most of these decisions are taken by the business. Okay, any business anywhere in the world wants to minimize costs. Now the problem with legal services is most times they are abstract, right? How are you going to quantify a merger and acquisition transaction? It's difficult. On the other hand, if you went and bought a car, it's visible. You can see the car. You can, legal services, unfortunately, because it's a service, it's difficult to attach value to. But I think the solution is not, pushing back with the institutions, because the institutions, lawyers do not make decisions on costs in these institutions. Okay, lawyers can persuade, decisions on cost, but ultimately those costs are met by the business. It's the business that decides that this is our bill for legal services. This is what we are willing to pay for legal services. I have always felt, and even this was before I joined, as an in-house counsel, that our avenue as lawyers to push back on the issue of fees is by regulation. Okay, when was the last time that the Advocates Act was amended? When? Why do you have institutions that are not technically law firms doing legal work? Why do you have agents, brokers drafting land sale agreements? Why do you have all these people who have not spent 4 years in law school and gone to the back course to? Why are they doing legal work? Why is it that fees for lawyers have not been amended from, in Uganda's case at least, since 2018, right? So because inflation happens, it should be factored in. But because fees are regulated, can only be elevated again by law. That is the purpose of law societies, in my view. Law societies should be able to lobby on behalf of all advocates to ensure that their fees are considered, and two, that the things that lawyers do, the services that lawyers provide, are ring-fenced for lawyers. It happens everywhere. It's just maybe in Uganda and I think a few East African countries where lawyers have been left to fend for themselves. So I think that's where I will dedicate my energy as an advocate. And I've spoken, in different places very strongly about this, that we need to be able to ensure that fees are provided for by regulation. Otherwise, a business is always going to try to get a service at an optimal cost. I hope I've been able to answer Alex's question.
Yes, I think you've been able to, and I also feel what he's also charging us as in-house counsel is that when we are on this side, let's protect the businesses on the other side. So rather than pushing them to the wall and paying them peanuts, let's pay them for the value that they deliver, and let's not underscore and give the work to the cheapest bidder as opposed to the highest bidder just for the sake of costs, but compromising on the quality and on the sustainability of the profession, but also the business case. So over to you, Ahenda. What's that one most important thing that whoever is listening in and viewing live online should take away from this conversation
Yeah,
on how
thank you,
clients
Brian.
think and how clients make their decisions?
Yeah, thank you. After Andrew's very heavy statements just now, it almost feels like a tongue-in-cheek moment, what I'm about to say. But I think given that I am in-house counsel, my thinking is driven by what the strategic intent is. And I think the one takeaway for me is that as in-house counsel, we must always balance risk, opportunity, and profit. So I think that is the biggest takeaway for me, is that, we always wearing these various hats. Yes, we are defenders of the profession as well. We are defenders of ethics. We are defenders of compliance. We are the champions of regulatory risk and mitigating it. But at the end of the day, our major role as in-house is to always balance risk, opportunity, and profit. And I think if our external counsel can understand that pivotal position that we play in our organizations, then I think they'll be in a much better position to work with us as business partners in driving the industry forward. Thank you.
Awesome. Thank you very much. What's that one thing, Andrew, that you want the listeners and viewers to take away on how clients think and how they make their decisions?
Yeah. So in-house, the role of in-house gives you access to the client. So I think we're better placed to know the mind of the client. The client wants solutions. At the end of the day, the client wants a solution to a business problem. So the most suitable lawyer is the lawyer who understands that solution, rather who understands that need and is able to respond to it. This can be anticipatory or by reacting to it. Okay, but I think we have already discussed that it's always better to anticipate than react. Maybe there is more value in anticipating. So the moment you understand that a business wants solution, because the business is trying to make money, so they want as less obstacles in their way as possible. Some of these obstacles are legal problems. So those legal problems sometimes are intertwined with actual business problems. So a lawyer has to be able to provide legal solutions to a business problem, and there has to be an intersection somewhere. It can't simply be legal solution alone, and and then it will be disjointed. So the moment we understand that the need is to solve problems, and the lawyer who best understands where the business is coming from is one who takes the day, I think we'll all have excellent careers as business partners.
Thank you very much, Andrew and Ahenda. Now, on my own, I would say, really, I agree with my panelists. It's a harsh world. There's the world of in-house counsel is quickly shifting. The future of the profession as we know it is quickly shifting. And as we bring this conversation to a close, I would just like to sincerely thank our panelists for the very thoughtful and practical insights that they have given us. A few themes stood out today, and I'll just highlight some of them. The first and most relevant one is that the clients are not looking for legal expertise. So to all the young lawyers that are listening in, please remember that they're looking for lawyers who understand their business realities, their regulatory environment, and their risk landscape. So if you can understand that, then you know how the clients think, and how best to position yourself. The second is that the lawyers who build enduring client relationships are those who go beyond the technical opinions to become trusted advisors, those who anticipate problems, as Andrew has said, and those who communicate clearly and provide practical solutions, as Ahenda has said. And third, as the legal and business environment continues to evolve, driven by technology, regulation, and changing client expectations, as we said, the advocates who will thrive are those who will remain commercially aware, who will be responsive, who will be adaptive, who will be quick on their feet. So for the many lawyers who really joined in, and I saw Senior Counsel Ohaga, it's a pleasure to have Senior Counsel in our midst. Special regards to that Senior Counsel joining us. So for the many lawyers, the message is clear. Please invest not only in the legal knowledge, but also in understanding how the clients think, how the organizations operate, and how value is truly delivered. I believe Andrew and Ahenda and myself have delivered what we perceive as value. So let's get rid of the misconceptions. Let's remember what we said we should start doing, what we should stop doing, and what we should continue doing. And on behalf of the East African Law Society, thank you for joining us. And a special thank you to my distinguished panelists once again for sharing your perspectives very, very generously. It's been a privilege. For our online viewers, thank you for joining in. This will be recorded and will be available online. You can always refer to it. And please share it with everyone widely, because these are tips that are not just for today, but for the future of the profession. Thank you very much, and have a good evening. Bye-bye.
Thank you, everyone. Have a lovely evening. Bye.
Thank you. It was a massive pleasure.